Okay, so welcome everyone to another event of the King's Forum on International Dispute Resolution, plus also to the class that you're in. As you know, we had quite a busy time last couple of weeks, and we'll have another event, but that's on Thursday, where in 2 weeks, where we'll have the Vice President of the European Human Rights Commission. Of course, that commission does not exist anymore, so the former European Human Rights Commission. And now we have a very special guest and friend, Markus Wagner, who teaches at Warwick. He has also taught before at Miami. He has, despite his relatively young age, I like saying that, because he's, I hope it remains like that.
I'm not sure what's coming now, so...
He has got...
I'm waiting.
He has had a very successful career. He not only taught in Miami, he worked at the Max Planck, where we met. He graduated from Stanford University. He clerked with the then president of the Supreme Court of Israel, Aaron Barak. He worked for Wilmer Hale in Brussels. And he's also very active in the Society of International Economic Law. And now teaches in Warwick in their program of international economic law. He has published widely on the topic. In fact, he has presented widely on the topic as well, from Bogota to South Africa. And we are very lucky to have him here today. His topic today is investment law's Uruguay moment, and as he combines investment law and trade law, I'm very much looking forward to what he has to say.
Well, thank you, Holger, for this kind introduction, and for everyone for coming. Some of you apparently more forced than voluntary, potentially, but I hope, the snickering indicates the more forced part. And the idea that I want to present to you is sort of indicative of the title. But when I mention the title, most people sort of look at me and was like, "What do you mean by all of this?" So I'll try to go through this. But essentially, what I want to do is, and the thesis in this project, which as of late is turning more and more into a book-length project rather than an article, is to look at how investment law is tracing the steps of trade law in more ways than one, right? And I'll try to point that out. I'll define in a second what I mean by the Uruguay moment. The Uruguay moment is actually a time span that runs for about 12 years. And at some point you have to make an artificial cut because, and I'll explain where I make that cut. And I then will try to show you that investment law is following a very similar path along the lines of trade law. Now, investment lawyers oftentimes sort of push back against this, and I'll pick up on that as well. But I do think that we see a debate in investment law which can be informed by the experience of international trade law. So we see debates, and I'm not going to talk about Trump today, to the extent that I don't think we need to, right? But we see highly integrative regimes, right? TTIP, TPP, despite the fact that they've been shelved, I think they'll make a comeback at some point in time. And we see not only an academic debate, we see a public debate about these integrative regimes, and we see international investment law and ISDS as sort of the protagonists in the public debate, next to chlorine-treated chicken and the like, that comes up. I'm a vegetarian, so I'm not really bothered by all of this. But other things may come down the pike as well, right? So the factors that caused discontent with the WTO, just to sort of look back a little bit, after 1995, were, I think, caused by the deeper integration brought about by the importance of a new organization, namely the WTO compared to the GATT, an increased awareness of the connection between trade on the one hand and health, ecological, social considerations on the other, and something that was seen by some as a threat, either real or perceived, of the traditional governance order that we had, right? And I think Europeans are generally a little more at ease with multi-level governance structures by way of the EU. And if you think about all of this, these criticisms are very much those that are leveled at against the international investment law regime at this time, right? It's almost exactly the same criticism that you see now that were in place in the late 90s and the early 2000s, right? I will show, or I will point out that there are important differences between the two regimes, but I find it fairly remarkable that these two very closely related fields either have contended or are currently contending with very similar critiques with a temporal lag of about 10 to 15 years, right? So that's why I say there's a little bit of a matrix that international investment law may want to look at. And if you think about the fact that the WTO still faces criticism, but you also, I think, look at the fact that the criticism has abated to a considerable extent, and we can debate whether that's just because we have a new someone has a new enemy, or whether actually certain things have happened that make WTO law less of an issue these days. I don't go as far as claiming at this point, I may do that in the future, I'm not there yet, that there is some kind of strict path dependency in international economic law overall that sort of premeditates this kind of development, but I do think that this development is something to keep in mind. And what that concerns is the Uruguay moment is institutional mechanism, procedural and substantive rule changes, and what I will show in the next few minutes is not only differences and parallels between trade and investment law, number one, I'll define what I call the Uruguay moment, and then I'll analyze some developments in investment law that are either similar or are functionally equivalent to the developments in international trade law. So let me start, or state at the outset, that I don't think that transplanting legislative developments or jurisprudential developments whole cloth is useful, right? Some people make the claim that I sometimes say that. I will state at the outset that I don't think that's the case, right? So if you think about certain investment law jurisprudence that basically take Article 20 jurisprudence off the GATT and sort of transplant it into investment law, I'm rather critical of that. I'm also aware of the structural differences. One is an intergovernmental system, the other one's a hybrid system. The results in both regimes are different. We have direct effective arbitral tribunal for claimants. WTO dispute settlement can only be executed after dispute settlement body action. The regimes, yes, are different. The damages are different. I see all of this, right? I see all of this. The centralized versus decentralized nature of the regime, and we have different epistemic community. But let me come to the parallels. When you look first at certain disciplines in trade law, there are some inklings in the GATS and the TRIMS agreement that already speak to that, but that's not at the heart of my concern. The linkages that I'm concerned about concern the facilitation of cross-border transactions through common sets of rules. If you think, for example, global value chains, you have very strong rules about non-discrimination in both trade and investment law. You have elements of what I would consider an international administrative system combined with constitutional elements in both fields. And they both certainly concern themselves with the extent, the context, and limitation of regulatory power and the need to find a proper balance between competing interests of investors and governmental regulation for public purposes. And I think that's ultimately where my discussion focuses on. So what is this Uruguay moment that I use as the title for my talk? It signifies a change that consists first of the institutional, substantive, and procedural reforms that came about through the creation of the WTO in January of 1995. It was a change that didn't come overnight, and it's an evolutionary process that spans from the creation of the WTO to the appellate body decision in Brazil retreaded tires in 2007. You can say that that's an arbitrary endpoint, but I'll explain in a little bit why I chose that particular case. If you look at the institutional change that happened, it was fairly clear that the system in the GATT needed changing beyond what the Tokyo Round offered and beyond the Tokyo Round agreement on dispute settlement. Too much consensus was required at the time, especially at the adoption stage of panel reports. It wasn't reverse consensus, it was consensus at that point. It was much more what I would consider a proto-legal system at the time rather than a full-fledged legal system. But one that was considered to be deficient with respect to the expertise, blockage, delays, and implementation. Certainly all of these remained. So what did these changes consist of? We see a change not only in the number of disputes that arise from 6.5 disputes per year in the GATT era to 24.5 in the WTO. So that's a significant change upwards. We see the introduction of negative consensus. If anyone has questions about this, I'm happy to go into detail what that means later on. We see the binding, or at least quasi-binding nature of DSB decisions, and certainly panel and appellate body decisions and DSB decisions and the remedies. We see the primary goal of WTO dispute settlement with the withdrawal or modification of WTO inconsistent measures. And all of these changes combined, right, were important in and of themselves, but they would have had limited consequences without important changes concerning the functioning of WTO dispute settlement as such as an institution. So let me come to the institutional point here. I assume some of you have taken WTO law as a course, and then you will remember something along the lines that appellate body decisions or panel decisions cannot add to or diminish the rights and obligations provided in the covered agreements, right? One of the central tenets of the dispute settlement understanding. But if you look at the appellate body's jurisprudence, my claim is that it brought about an entirely new quality of jurisprudence that not only exhibits remarkable substantive differences to the jurisprudence of GATT working parties, but also shows a wholly different understanding of the constitutional position of the bodies tasked with adjudication, right? The self-understanding is very different. The original piece was for the appellate body to not be the centerpiece that it actually turned out to be. If you go into some of the debates in the Uruguay round, it was very clear that appellate body members were not supposed to be permanent members. They were supposed to be part-time adjudicators with retainer fees and so forth. But I think it's correct to say that they were they very much turned out to be, or the appellate body turned out to be the centerpiece of the dispute settlement in the WTO. It was supposed to be used sparingly, only active in extraordinary cases when panels were making fundamentally flawed decision, as it was called. But things turned out very differently. The track record of the appellate body shows that it's exercised its function of judicial review in, I think, a very meaningful way. Some would say expansively. We saw that come to a head in some ways in the summer of 2016 when appellate body member Chang was not reappointed. But it also took the task of reconciling competing values within the WTO constitution very seriously. And I think Joseph Weiler, for example, has convincingly shown that the mere existence of the appellate body has led to a shift in the organizational culture of the institution. And I think it's hard to argue that the appellate body's tone and content was sharply critical of the legal reasoning of a number of panel decisions and early examples or the earliest examples include gasoline and shrimp turtle. I think there the appellate body is already sort of gearing up towards changing the entire jurisprudence of the GATT years in important ways. The second element, I'll keep this brief and at the risk of oversimplifying things, is that the appellate body's jurisprudence has, at least in my mind, finally taken the justifications in the GATT much more seriously than the GATT than was true in the GATT years, right? And when I say justifications, I basically talk about Article 20 for the time being, right? I don't consider Article 20 to be exceptions. I know the title of that particular provision is exceptions, but exceptions tend to be interpreted very narrowly, at least in most legal systems, and I don't think of the values that we see in Article 20 as exceptions that you have to work hard to actually elevate to be meaningful, right? If you look at GATT decisions such as U.S. tuna, Canada herring and salmon, You see, for example, that the terms relating to and necessary in Article 20 were basically defined almost exactly the same in the least restrictive means test, right? So hardly anyone had a chance to ever jump over the hurdle of that. Keep in mind also that it was very much a top-down approach rather than a bottom-up approach, as the appellate body made clear in its jurisprudence with respect to Article 20. And the panel stuck to that particular line of reasoning for a while and were convinced only over time that they should change. The panel itself called its jurisprudence in the tuna case, for example, a fairly narrow approach. The GATT was seen as serving trade purposes only, as protecting against potential abuse by GATT contracting parties through cloaking protectionist measures in health or environmental measures, and was very much characterized by functionalist arguments stressing trade objective to the virtual exclusion, I think, both in terms of how the arguments are made and in terms of the end result of all other policy considerations. And that in turn meant that the actual sort of function of the chapeau to curb abuse was never in place, right? It never sort of played the role that it was meant to be. The WTO jurisprudence is very different. If you look at decisions ranging from gasoline to retreaded tires, we see nothing short of what I consider to be a jurisprudential sea change in how Article 20 has been interpreted. You wouldn't know this if you looked at the initial reports, because I think the original appellate body members were very careful. They knew they had a very powerful tool at their disposal. Reverse consensus was important, and so continued a little bit in terms of style and language the GATT jurisprudence, but set markers very early in that they said necessary and relating to are very different concepts. We need to expand their meaning and not interpret them very narrowly. So it left ostensibly in place some of the GATT jurisprudence, but gave, for example, Article 20G on environment a much more expansive reading. It had found that previous jurisprudence had turned Article 20, quote unquote, on its head, and thus gave, I think, much, much greater regulatory autonomy back to states. If you look at the jurisprudence that follows, that line was then carried forward. The appellate body says that WTO members had autonomy in determining their environmental policies, that WTO law was closely tied to public international law as a whole. We need to look at it much more coherently and holistically. The WTO was no longer, quote, a club where like-minded officials could communicate without having to spell out things in confrontation procedure, producing clarity, end quote. And overall, the appellate body, at least to my mind, demanded an interpretation by panels that gave meaning to both the affirmative obligations, say Article 1, 3, 11, but also the justifications, and to think of them as one organic whole and no longer sort of giving a lot, sort of paying some lip service to Article 20's application, but not really providing meaning to it, right? If you then think about the outcome of the cases, they're not remarkable for the outcome as such, right? But rather for the way the argumentative structure has changed. Both in gasoline, for example, and shrimp, you still see the United States losing, right? Partially or almost entirely because the application the way it was, or the application of the domestic measures were still discriminatory, right? And so I don't buy the narrative that the WTO was anti-environment or anti-health. It simply looked at the way the measures in place in the US with respect to gasoline and shrimp were applied, and they were applied in a discriminatory fashion, and therefore the appellate body had virtually no choice if it meant to take Article 20 chapeau seriously, but to not have the desired result there. The other, I mean, one of the tests you can apply is whether entrenched interests were welcoming this newly emerging jurisprudence, and they clearly didn't, right? And it was a departure from almost half a century old way of the things that have been done. which was in the GATT, we find a solution diplomatically to situations that were amenable to the parties involved, upholding the multilateral trading system, even when such policies were detrimental to other legitimate policy goals, such as human health and environment. And this new jurisprudence then changes the power structure within the WTO and had been very carefully safeguarded by the GATT contracting parties. The third element that I'll just simply point to, and we can go into this in the Q&A because I want to get to international investment law relatively quickly, is the development of a fairly principled jurisprudence. And here I would point you towards, number one, the development of a true jurisprudence of proportionality in WTO law. And I see this, for example, in Brazil retreaded tires. I keep forgetting whether it's paragraph 178 or 187. I think it's 178. If you, like both of us were, brought up in good German public law fashion, I think you will see in this particular paragraph all the elements of proportionality analysis without them being named as such, right? Is the measure capable of achieving the end? Yes. Are there less, not least, are there less intrusive means to do this? Yes. Do we have to do some kind of weighing and balancing of the competing factors? Yes. They're all there. You can basically sort of tick the boxes. So that certainly has come to the fore, and I think has found both in Korea beef and ultimately in Brazil retreaded tires its application. The second element is the precedential value / predictability of the decisions. For a very long time, panels had continued to push back against the jurisprudence or the binding, quasi-binding nature of the appellate body. And the best examples I can give to you is the SPS jurisprudence. You don't have to be an expert on this. I happen to sort of write on this, so this is the area that I know fairly well. And the appellate body there took a very different line with respect to how you translate scientific uncertainty, for example, into legal decisional processes. And the panels for a very long time, with almost as many repeat players as was the case for the appellate body, interestingly, fought what I called a rearguard action in some of my prior writings, right? And the appellate body was very clear in a number of cases, not only with respect to SPS, but also with respect to other treaties under the WTO umbrella. And pretty much this culminated in U.S. Steel, where the appellate body says WTO members attach significance to reasoning provided in previous panel and appellate body reports, which are often cited by parties in support of legal arguments and dispute settlement proceedings and relied upon by panels and the appellate body in subsequent disputes. It then expressed its very deep concern about, quote, the panel's decision to depart from well-established appellate body jurisprudence, clarifying the interpretation of the same legal issues, unquote, and went on to state then, the panel's approach has serious implications for the proper functioning of the WTO dispute settlement system. And then it, of course, mentions, look, you're also in a hierarchy. You, the panel, are somewhat below us, appellate body members, and there has to be a meaning to this. So if the system is supposed to function, it said it would be difficult to realize the hierarchical structure contemplated in the DSU or in the design thereof if there wasn't some kind of precedential or quasi-precedential meaning. And if panels continued to disregard appellate body decisions, it said it would constitute a failure to discharge duties under Article 11 of the DSU, and I think that's about as much as you need to understand. If there is a slap in the face towards panels, I think this is sort of it. You don't carry out the task that you're set out for you. The final element is towards much more transparent procedures in the WTO. And there I'll just simply point out that we have, not fully, but we see much more open, transparent procedures. We see amicus curiae briefs allowed to be submitted, albeit with still some problematic features. Some countries don't like to be, or want the doors closed and continue to want the doors closed, but I think you see much more transparent procedures in WTO law. And that's sort of the Uruguay moment. That's the matrix before which I now will talk about investment law and try to show you that there's very similar pathways being taken there. First question you may ask is the international investment law's inchoate institutional framework a stumbling block, right? We don't have a place to turn to. in the same way that we have with the WTO. We can all go to Geneva, right, and we can knock on the door of the WTO, but which door do you knock on with respect to investment law? There's a disparate institutional framework, there's a disparate treaty framework. Stefan Schill will try to convince you, and I think he writes convincingly, that there is a multilateralization of investment law, and I actually believe that he's right in that way, but it's not the same thing as having one institution, right? We have ICSID, and the majority of cases certainly take place there, but I think that's only one step. I, for one, don't think that that we can't have some kind of appellate body mechanism in investment law, and I'll explain why. I don't think unlike others, I'm not opposed to an appellate mechanism. I think that would contribute to a much more coherent jurisprudence, something that some of the investment lawyers deny even exists an incoherent jurisprudence. I think if you look at certain cases, I think it's pretty clear that there's a need for a more coherent jurisprudence. I think an appellate body has the added benefit of having a higher degree of impartiality. And I think that's even true within the WTO between panels and the appellate body. If you, again, SPS jurisprudence is fairly instructive there. I think the fact that even in WTO law, you can appoint on the panel stage one member from one party and one member for the other is a problem if you think about judicial independence and impartiality. And I don't think that the annulment committees have a real potential to serve as a quasi-appellate mechanism. So we also see what I would call the coming of age of public policy considerations in investment law. We're seeing a resurgence of public policy considerations over the last decade, and we see this on two levels. We can see the changing legislative landscape in investment law, and we see a jurisprudential change. So let me talk very briefly about the changing legislative landscape. We see this in various forms. We see a shift away of interpretative power away from tribunals through interpretive language, either ex ante or through committee. We see preamble language recognizing the importance of health and environmental concerns. I know some people think that that preamble language does not mean anything at all. I am happy to say that why I think it does matter, and I will just say briefly that I think it matters when terms are unclear. Then you can certainly turn to the preamble for informational purposes. I don't think that they're in of themselves binding in any way. But you also see the inclusion in operative part of treaty language that is either declaratory of the regulatory autonomy of governments, although I'm not quite clear what the effect that language actually has. Then we see something very similar to the inclusion of Article 20 in various forms. Norway's model BIT that came out a year or two ago was, I think, the boldest step, and it even included the precautionary principle, which I think does exist and isn't just some kind of fata morgana, but I'm happy to talk about this later. Canada has included something akin to Article 20 since 2004. You see carve-outs with respect in the TPP with respect to tobacco and so forth. A second avenue through which public policy considerations have been introduced as a counterweight to the rights of investors is through the jurisprudence of international investment tribunals. I'm happy to talk about how that development shakes out at the moment, but I do think you see that sort of the competing values gain much greater prominence in the jurisprudence. The principal jurisprudence part, since there isn't an appellate mechanism, I sort of have to go through a sort of some kind of substitute. And what you see there, and what I would identify as a substitute, is the role of precedent in international investment law. And we see real fights going on over that particular issue, right, between various panels. We see developments, again, in coming from the European side to establish an appellate mechanism. You may have heard about this. The US has had it in its model BIT for a very long time, but when push comes to shove, doesn't seem to want to commit at this point. We'll see what happens post-Trump, because under Trump, I did mention him. No one knows what happens to any of the institutions that we hold dear. But I think there's a whole range of arguments in favor of an appeals mechanism that are laid out. We see various iterations of this in various places, and I'm happy to go into greater detail here later on. Like I said, proportionality also rears its head in investment law, and I think that really shows the sort of rise of a principled jurisprudence, the way I at least understand it. You see this in a number of cases, although I think the jurisprudence in investment law is a little bit all over the place. It's either a shortened version of the proportionality principle, it's a curtailed one, sometimes, but I think we're moving in the right direction. Then finally, transparency in international investment law. We saw in the past very much an era of confidentiality, in which arbitrators may have been informed by their origins in commercial arbitration, where we have the equality of arms and where the parties can agree in a commercial contract that this does not concern public policy. I think that that position is no longer tenable, and I think we see less and less clear statements to that effect, at least in the public light. We see then very timid steps from confidentiality towards greater transparency in international investment law, both under ICSID and UNCITRAL rules. There has been certain changes in that regard. We then see, sort of as the culmination, quote unquote, the Mauritius Convention, which has unfortunately not been ratified widely, and I don't see that happening and having a large impact at this point. So with that, what I was trying to show is that none of these, that we see a retracing of the steps. I don't think that, or let me say it this way, that none of the changes on their own are sufficient in any way to bring about the much needed change in international investment law. I think the WTO showed that these changes were interdependent, right? That the institutional change was necessary, the procedural changes were necessary, the substantive changes were a result of that. They were thus a part of a larger package that were able to transform the regime of the GATT into that of the WTO. Some argue that the ad hoc nature of international investment law makes the application of a principled jurisprudence much more difficult. I think that's right. But even those that are skeptical, I think, appear to agree that even in the absence of a unifying appellate mechanism, there's at least a possibility to create an overarching structure through the process of quasi-precedent or the multilateralization of the international investment regime, or a combination of both. So I am somewhat hopeful. I think my contribution here is meant much more constructive than anything else. I don't think that we should just get rid of investment law, right? I think investment law needs reform. It needs it in more ways than one, and I think WTO law and the experience of the WTO as an institution can provide some kind of guidance towards that end. So let me leave it there. I've probably spoken too long.
No, absolutely.
And
fine. Thank you so much.
Thank you.
This now gives us the wonderful opportunity to discuss, and I think there were quite a lot of things to discuss. Anyone who wants to start?
I'm not a lawyer or a scholar in this area, but I do have a question. After the UK leaves the EU,
Brexit had to come up.
absolutely. I mean, this is a major, obviously a huge issue.
Right.
You can't understate it. Do you think that the UK will have to find
think that the ECJ is available as a venue after Brexit, right? It is not part of the EU. The ECJ is not your venue, right? Whether you want to have ISDS or not is an open question, right? You don't have to have a trade deal with ISDS if the other party agrees to not having it in there. The vaunted trade deal with the United States that may or may not be a good deal for the United Kingdom, given power disparities and given the fact that it looks like, I need to be careful how I phrase this, given that this is a quote. It looks like, to me, what happens at the moment looks fairly desperate, right? Especially from the UK side, and a desperate negotiating partner will give in to a lot of requests. The US will almost certainly want ISDS to be in any kind of trade deal with the United Kingdom. I'd be really surprised if the US said it didn't want it. It's been wanting it all along with almost all trade deals. Certainly if you look at TPP, and again, one never knows what happens under new President Trump, right? But if there's any kind of continuity, then that would certainly be the case, right? So I say this with lots of caveats, right? Given the power disparity and given all the circumstances, I would be hard pressed to imagine a situation that would not include ISDS. And again, I don't find ISDS as such objectionable, right? As long as it carries out its mandate on decent terms and in proper ways, right? And that includes an epistemic community that understands that investor rights do not necessarily trump public policy considerations, right? And I think my point here with this talk was to show that I think that was the case in the gap years up until 1995. The appellate body very much changed that jurisprudence, not in the outcome, but if a government at this point wants to make an argument to justify its measure under Article 20, it could successfully do so. It could successfully do so. I think that the reason is, I've asked someone in the EC Commission a little while ago why the EC Commission wouldn't, or, so think about the Seals case. I don't know whether you're familiar with the Seals case. But think about it this way. Given that in WTO law, the remedy system is such that you buy yourself 3 or 4 years in which this is all litigated, right? You can basically give in to domestic constituencies, right? And I think that may have been the case in the Seals case that went up before the WTO, in which Greenland communities were allowed to do something that native Canadian communities were not allowed to do, namely hunt seals, right, and sell for a little bit longer. My point is simply that if there isn't domestic pressure to keep a particular measure for the domestic constituency of either shrimp farmers or sealers or whatever else in place, there is nothing that prevents a government to bring an action that could withstand scrutiny under Article 20. That's my very clear position. Governments don't want to because of domestic pressures. They get it another 3 or 4 years if someone even brings a case. I think that's very clearly the incentive structure that's set by the dispute settlement understanding. And I do think that changeover, right, that happened in the WTO happened over a fairly long period of time. It took a while, but it took institutional changes and all the changes that I outlined. And I think if that takes hold, then I think the criticism of international investment law that we see at the moment, it being a private court, which is sort of a characterization I still have problems with, may actually not entirely vanish, but may decrease considerably. But I think that takes a lot of change in a community that's very set in its ways, right? And I mean the epistemic community of investment lawyers.
I think to add one point on the vote leave criticized the proposed EU-US free trade agreement as endangering the NHS, and I would presume that was partly because of fears of ISDS. Now, it will be interesting to watch to what extent you can have an NHS carve-out in a situation in which the negotiation partner is the UK. And then, of course, comes the Trump uncertainty. Will this be a Trump gift to the UK to have an NHS carve-out? Is that likely, or is the more likely scenario that Trump regards himself as a master negotiator with an America First policy? If you go to the USTR website, you will see that their landing page now has America First trading policy. What is the more likely scenario? It's anyone's guess at this point, but given the normal measure of American politics, it's interior politics that trumps external considerations. So it will be America First that wins, would be my guess, but it's a guess.
I think that's right. Although on the other hand, if you look at the TPP, for example, this was an American project. I mean, from front to back. And I've tried to lay this out in analysis on the SPS chapter in the TPP, which you should not read, right? Because it's very sort of arcane. But I think if that carve-out were to happen, then you pay a price for that in other areas. So imagine, I've only lived in this country since June, right? But I understand that the NHS is sort of one of those things, right? That one does not want to get rid of, right? Or endanger, right? Just like the BBC, or a certain,
or cricket,
or the Queen, or Heritage England. Right? But if you do that, then you have to give something else, and so that's a steep price to be paid, because you then have to tell the investors or the health industry in the US, you can't have that, but maybe we can get something else for you, right? And so you can try, but it depends on your negotiating position.
Thank you. It's very interesting. I'm not a lawyer, I'm an economist, so this probably motivates my question with 2 points. Aren't there 2 distinct characteristics that differentiate international trade and international investment that limit the sort of the convergence or the following of investment law to trade law? The first one is that investment has a different time cycle. So investments tend to be for a much longer period of time. It's not normally spot transactions or contracts. That would have an impact. And the other is the different international flows of trade movements and investment movements. And so different parties are invested in different countries in different ways than the trade patterns go. And that changes the power dynamic of the states and the investing organizations compared to the trading environment.
So the time cycle, I don't think that's right. If you look at sort of global supply chains in the trade area, they're fairly long term. With respect to certain products, not with every product, but with respect to certain products. So think about the car industry. If I were the car industry at the moment, I'd be really scared of certain pronouncements by the Trump administration that basically say we want bilateral trade deals and we want to be able to cancel them at 30 days notice. Because the 30-day notice period does not give you a whole lot of time to reconfigure your supply chain, which is very, very complicated even in, things like this, right? So I don't know that the time cycle is all that different. I think there are differences in that, and this is something that I think one has to take seriously, is that if you expropriate in some way, shape, or form an investor, or if you treat the investor unfair or inequitably, that you may wipe out the entire investment in that one particular project, right? I take that very seriously. On the other hand, as long as it's not done not discriminatorily, right, and as long as certain due process elements have been put in place, as long as you have certain timelines in which you can sort of recoup some portion of your investment and so forth, I find that completely within the realm of regulatory autonomy of governments to do that, right? So I think of, for example, I mean, there's other elements that you would have to add to this, right? And you may have to pay compensation for that. But I'm much less sort of, one can start to think about how much compensation one should give, right? Does it always have to be market value plus however X many years, right? And if you think about Australia plain packaging of cigarettes, that as such didn't bother me. Right? It's just sort of the normal, and investment tribunals have taken note of that, right? And not only in this particular case, but also before that. There are certain decisions, although the jurisprudence diverges in great many ways, that basically say, look, investment, and I think this must be right in some way, that investments carry risks. And the question is simply, how do you allocate the risks of an investment? And certain tribunals seem to want to place that risk almost entirely on the state, and certain investment tribunals place that risk, I think that's right, sort of more on a shared basis. I have yet to see a case where you had all the risk is borne by the investor. I can't think of one where I really saw that. And so I think that's where I would come down. Your second point, can you repeat that one?
So it's on the different patterns of trade flows compared to financial flows.
Mm-hmm.
So for example, a lot of investment flows will tend to be from developed countries into developing countries, and the IFCS sort of settlements have tried to protect the sort of the developed country-based investors from expropriation by the developing countries. When you don't, in trade, you don't get that because developing countries are not big trade consumers of developed countries because they don't import that much. You don't have that. That's not the dominant dynamic.
Yeah,
Different parties, different countries within.
I think that was right up until about 10, 15 years ago. But if you have economic statistics to prove me wrong, then I'm perfectly happy to accept that reality exists. But if you think about investment loss change that we already see, I think is partially due because we now have multidirectional investment flows. So what we call developing countries, now we see investors from what we call developing countries bringing suits against developed countries, right? And that has led to a number of developed countries bringing in sort of Article 20-like structures, right? That say, we want to keep our environmental protections, right? And so I think there's, that's no longer the case to the extent that I think you may have in mind, right? And so I think that partially explains that. I hope that is responsive to your question.
There's no other question. I have one. On the parallel, I mean, you said at the beginning it's not a perfect parallel, like no parallels are always perfect in law. I was wondering, your Uruguay moment was actually not a moment, but a period of change.
It sounds much
and
better.
yes, that's true. The Uruguay period sounds a little bit weird. But in trade law, in your trade law parallel, that was over. You said the Uruguay moment ended with Brazil retraditised. So in the investment example, what would it take for the Uruguay moment to be over? The coming into force of the European Union's proposed multilateral investment court?
That would be part of it. Right, look, I said at the very beginning that the end point is almost arbitrary, right? Because it just sort of, I think of proportionality as a fairly important element in all of this. And I look at Brazil retraded tires and I look at paragraph 178 or maybe 187, one of the two, right? I think that's sort of an important marker for me. But I could choose something entirely different, right? So I don't think that one of these elements is enough. Right, so just having an appellate mechanism of sorts would depend on the efficacy of that particular appellate mechanism, right? But that would still not be sufficient in order to actually move the system substantially into a different sort of onto a qualitative level from my perspective. So you would have, I think, transparency is moving in a reasonable direction, but I think it could still be more open. The fact that, for example, we know that there are some investment awards out there that we still can't get our hands on really bothers me, right? Because I don't think of the fact, and there are, right? Sometimes outlets like IA Reporter basically sort of say, oh, we have something new that no one has known about before. And I just wonder, in what I consider a system of public adjudication, or of adjudication over public law matters and public matters, that should not be the case. So it's entirely normative, right? But one still has to explain to me why that should be kept under wraps, right? I understand it to a degree, and I say to a degree, in commercial arbitration, right? You know this, almost no one else in the room knows this. I happen to like bicycles a lot, right? And I sort of lost my thought right now. Like,
I was also wondering how this will fit in.
Yeah. I'll find my way back. But the
It was about commercial arbitration.
commercial arbitration, right? There we go with bicycles. Now I know. If I have a contract with you about bicycles, that has pretty much no public policy implications that I can think of, right? Delivery of bicycles, you'd order 10,000 from me because I make good bicycles, or rather the opposite, Holger makes really good bicycles, and I order 10,000 of your bicycles. That has, if we somehow run into a problem with delivery or whatever, or quality, it has no public policy implications. I think the same is not even true any longer with arbitration over labor issues, for example, right? I think that has serious public policy implications domestically, so I would actually even push back on that front. But once we talk about the supply of water, once we talk about a landfill, these are completely public policy considerations, and there's absolutely no reason from that I can see that those awards should not be public, that the reasoning that both sides put forward, as well as the tribunal puts forward, should not be made public. You need to be able to debate this. And if at least the award isn't public, then it's really hard to debate anything, right? And so that's where the bicycles come into play. Yeah.
Any further questions? So this, yes.
Thank you for the talk. There's been a lot of discussion how this appeal mechanism, appellate mechanism, would even be possible.
Mm-hmm.
So what do you think is even in the realms of possibilities, especially now seeing that even basic human rights are being challenged in certain parts of the world where you wouldn't have expected to happen? From political will side of things, how could we ever negotiate, or who would have the negotiating power to drive any kind of appellate mechanism to a certain point?
So let me divide this into two parts, right? I think that your question was laid out in two parts, right? Number one, how can we think about this to begin with? And then what are the politics of this all, right? I think I may just take the second first, right? It completely depends on the will of the political decision makers to actually make this happen, right? I mean, there's really no way around this, right? But that's a political question where I think an institution like the EU, prior to Brexit, would have had a very convincing role to play. And prior to these past 2 weeks, I think the EU will find itself having to fight defensive battles more than it wants to, because my interpretation of the new administration is that the EU will have to defend itself much more vigorously as an institution and as an entire project against the US administration. Because I think the administration looks at many things as a zero-sum game and sees the EU as a viable counterpoint, and therefore wants to potentially at least diminish it, if not more. How can we make this happen technically, right? Sort of now we get back into law a little bit, right? One way I think is, and this is an incremental change, right, is the EU proposal, that more and more partners eventually buy into that system. That's one way of doing it. It's a very piecemeal approach. I don't find it very satisfying, but realistically speaking, that's the only approach that I think works. I don't necessarily think that the Mauritius Convention on Transparency is necessarily a good blueprint, right? I find that really tricky and hard to make work sort of down the line. So I do think it has to come almost sort of organically by some players pushing that idea forward and then convincing other large players to also adopt it, right? Theoretically, the 2012 US Model BIT has some kind of appeal for an appeals mechanism, right? It happens to be politically not palatable to players in Washington on the lobbying side, because supposedly it takes so much longer. Well, welcome to the world of public policy and no longer the world of commercial arbitration, right? You may want to get your very quick fix in commercial arbitration in dispute settlement, but I, for one, think I'd rather get a dispute settled correctly and with expectations being laid out of a consistent jurisprudence rather than having it be done quickly. So that's where I would come down on this. So really, I think the European Union proposal, the Commission's proposal, is at this point the best one that we have, and almost entirely the only one that seems plausible, because I don't see the gumption at this point for an entire reworking of the 3,500 plus international investment agreements that we have that somehow come magically under one umbrella that may be set up within existing or outside of existing institutions. So I don't have the panacea, right? But I do think that an appeals mechanism has a lot of advantages and a lot going for itself. And the question then is, I think, much more one of political will to make it happen. I find it much more difficult now than I would have found it a year ago.
Maybe on a positive note, I think, yeah, you have to then blend out the last couple of weeks and in particular the Trump administration. But on the positive note, I would say when CETA was signed and then changed in the legal scrubbing process to include an investment, something resembling the investment court, I think that at first there was a lot of debate of, oh my God, how can the EU force Canada to do this? How is the EU so much stronger than Canada for Canada to actually agree to this? And the last couple of weeks have shown that actually that is not what happened. This is now also Canada's project, and the current Canadian administration is rooting for this project as strongly as the EU, and it's no longer just an EU project. So there's a
I mean, it was more than scrubbing, let's be...
Yeah, no, it was absolutely not scrubbing. It was, well...
It was rewriting, I would say.
Well, it depends on your definition of scrub. It was scrubbed away and then it was scrubbed in.
Yeah,
but it's not what normally happens in that
right.
process.
But I do think I think you put or you hit the nail on the head, right? I think it changes, and that goes back to the second part of your question, right? It changes with the politics. The current Canadian government wants this and thinks of it as a good thing, right? And I think in some ways, surprisingly, as a counterpoint to its neighbor to the south, right? Even under the Obama administration, right? Convince more countries to go along the same route, use the soft power that the EU, in my mind, undoubtedly has, and wields in international economic circles all the time, right? I mean, people always say sort of either the Mars-Venus connection between the U.S. and Europe, or sort of much more sort of robust. I think the EU is incredibly robust when it comes to trade and investment interests. I think it's not shying away in many ways. I think it may do it in maybe ostensibly nicer ways, but I don't think that it doesn't use its power. And I think we see this with I think Vietnam certainly has it. I think Singapore has does Singapore have an appellate mechanism in place?
I think it didn't have the same thing because it was drafted before.
Right. But I think that's the blueprint. Certainly, if you look at the Commission's website at this point, this is a blueprint that they want to use going forward. And we will see. I mean, I'm trying to imagine how a future UK EU trade deal would look like. It would presumably have to include something along that line, and I would be hard-pressed to think that the EU wouldn't want to include something along an appeals mechanism even with the UK. Why not? Why not? You're
So if there are no more questions, then I have something to inspire the students. Of course, there's wine next door, and we can move the discussion next door. Thank you very much.